which is probably one of our more unusual topics, where we're trying to focus on the legal issues, or some of the legal issues facing parent carers in terms of their wills, trust, and general estate protection. But just to be clear to everybody, we're not today looking at the actual care issues of the child. The scenario that we're trying to address and consider is that of a parent or the parents of a child with care needs or capacity issues. And as the parents get older, they understandably become increasingly concerned about what happens if they themselves needed care, or became incapable, or eventually were to die. Now, the majority of cases that we come across, the child's needs are generally, primarily, I would say, funded by the state or by the local authority, perhaps with some top-up funding from the family. So the fear that the parents have is what will happen in the future in the event that assets pass from them to their child. Just for those of you who don't know us as the Care Advice Line, we've been commissioned by Gloucester County Council now for, I think, 11 years, basically to provide advice and guidance on care, its funding, and the associated issues. And as most of you will know, those associated issues kind of expand sideways to cover pretty much everything. And what we've tried to do with the Carers Hub sessions is to put together 1-hour sessions on subjects that are relevant to lots of people or that are of interest to people. So we were a bit skeptical about running the parent carers session because it's a relatively smaller group. But we had a strong response last time, so we decided to run the session again. Now, we do include in our suite of webinars sessions on wills, estates, and trusts. So I don't want to repeat myself, but there is inevitably lots and lots of crossover. So if I say something today that doesn't make sense or that you're not sure of, then please feel free to just shout up and let me know. So what we've tried to do is look at this issue from 3 specific time periods because the situation changes through the progression of time. The first one is when all is well, there is no parent care issue, illness, or capacity problem. The second one is when one or both parents need care themselves. And the third one is in the eventuality of death. And slightly oddly, I would like to deal with them in reverse chronological order, mainly because I think that will make more sense. So I'm going to start with the situation on death and the position that people find themselves in that scenario. And still today, the vast majority of people I come across leave their estates initially to their spouse and then to their children, to their surviving children thereafter, through what are commonly referred to as mirror wills. In other words, mum leaves everything to dad and then the children, dad leaves everything to mum and then the children. And that's fine if there are no issues for the surviving spouse in terms of their capacity and they don't have a care need, then no money will pass to the child, and the survivor would have the surviving parent would have the opportunity to look at the situation and decide how best to proceed. The problem arises if the survivor is either ignorant of the issues, just not aware of what lies ahead, or if perhaps they don't no longer have the capacity to change their will, or in instances where there's no will at all, and the first person dies, but dies intestate. In any of those circumstances, then the likely outcome is that your child will inherit some or all of the funds. So potentially, a person who has had their care needs fully funded by the state might suddenly find themselves in a situation whereby they own their parents' house, their capital, possibly their pension, all of which is great news for Gloucester County Council or any local authority, because it will now relieve them and absolve them from their financial responsibility, because that that child has now effectively become self-funded. So what we're really trying to do today is just look at some of the considerations that you might want to take to prevent or avoid or change that situation. So the first and simplest step is for the parent or parents to change their wills and effectively disinherit their child so that they are no longer named as the default beneficiary after the spouse. Because this raises all sorts of questions and issues, which is who will receive those assets instead. And I've spoken to people who have suggested it might be perhaps a sibling, a child who has no care issues, a close relative, a friend, somebody will be willing to hold the funds on behalf of the child. The trouble is, unless everything is absolutely perfect and wonderful, that is just fraught with difficulty. So you might agree with somebody that they will use the money you leave to them to support and assist your child as and when needed, but you've got to really look at what would happen in practice. So who would pay the tax on the gains or the interest? What happens if the person that you've asked to take on this role lends some of the capital? What happens if they divorce, if they die, if they marry? All of these things are likely to create difficulty and confusion. And of course, overriding all of that is the issue of responsibility. I have to be honest, if someone asked me to do that, it would be a very clear and emphatic no. Far too demanding, far too onerous, far too problematic. So I think the doorway to a possible solution is through the use of a trust, which often causes people to think, oh, that's far too complex. The best way to think of a trust, in my view, is to realize it is a separate legal entity to yourself. Think of it a bit like a company. You might control the company and the money, but it doesn't actually belong to you unless it's formally distributed. So your will can detail who will run the trust. They will be the trustees. They will be responsible for making decisions about investments, how funds will be distributed. Your will would also establish a trust deed, which will set out the most important issue, which is who can benefit from the trust. And then alongside of that document is something called a memorandum of wishes, which basically is your opportunity to write in simple terms your directions, your instructions to the trustees, what you would want them to do, and more importantly, what you wouldn't want them to do. Now, important thing to remember is a memorandum of wishes is not in itself a legally binding document, but it is extremely powerful. And I can't recall in the 30 years I've been doing this, anybody who has dared to ignore the instructions that the trustee has set down. So within the trust, the important thing is that the money is ring-fenced. So it's safe from consequences and attack in the event of death, divorce, or bankruptcy of the individual trustee. But as I said earlier, the most important thing is that the money is not owned by the beneficiary unless or until it passes to them. So it's completely separate and wouldn't form part of the basis of a means test. Trusts have their own tax rules, legislative protection under the Trustee Act. So it's an altogether better option than leaving your ultimate estate to a friend, neighbour or family member with all the responsibilities that go with that. Now, the problem for most parents that I speak to is who should be appointed as a trustee, because it's not everybody's cup of tea. I have done it for family members twice, and on both occasions swore I would never do it again, because it's just a bit, it's just, again, onerous responsibility to make sure you do everything right. But it can be helpful if the trustees have some assistance and some help, and that would ideally come from a professional. So they would have access to a solicitor, an accountant, a financial advisor, whoever it may be, to bring guidance and assistance to them so that they're not taking on board the whole responsibility. I would also suggest it's useful to have one or more trustees, to share the work and the responsibility, to have the opportunity to discuss things, but also to provide continuity if anything should happen. The downside, of course, is all of these things bring with them a potential cost. Trusts need to be registered under the Trustee Registration Service with HMRC. It's not a big issue, it's not an onerous issue, but it is something that has to be done. There might be tax returns to complete. And as I said, professional advice for investment issues, for example, and for some other legal issues. But what I would say is that in the vast majority of cases I come across, those costs would probably have existed anyway, because it's unlikely that the person that you've left in charge would have all of those skills and abilities. I think where the costs can ratchet is where you appoint a professional trustee formally. Yes, it's all very helpful, great to have somebody on board, but you will have to pay for their services as a professional. But if you have no family or friends who you trust enough to make the appointment to, or if they're just not willing to do it, or if they'll only do it with some assistance, then you may have to consider a professional trustee. So a solicitor, a legal practice would be the obvious people to fill that role. And undoubtedly, a professional trustee will bring all sorts of expertise, experience. They'll be able to deal with the legal issues that crop up. And perhaps most importantly, provide a degree of independence and impartiality from just the family members that may have been nominated. My own example is a good illustration. I took on the role of trustee for a relative who was diagnosed with cancer at an early age, and she left everything to her young son, who was 18 at the time, but she didn't want him to have access to the funds until he was 30. And all that happened every year was he would come and ask, could he have some of the money from the trust to progress various things that he had in mind for his career. And it was always a constant dilemma to think, should we, shouldn't we? Is this a good idea? Is this a bad idea? So it's always handy to have at least one other person who you can kind of bounce these ideas of. And if you have a professional trustee, they can perhaps provide independence if one family member says yes, one family member says no. If you do go down that route, I would always suggest looking for somebody who is a member of STEP, which is the Society of Trust and Estate Practitioners. Now, they're a global professional body of lawyers, accountants, trustees who can help families plan for the future. So a full member is known as a TEP, and that would definitely be my first port of call, to look for that qualification and that membership. You might also look at the Association of Lifetime Lawyers. They were formerly, you may have come across them as Solicitors for the Elderly, which was a concept set up by a group of solicitors back in the 80s, late 80s into the 90s, really just to specialize in helping elderly clients who had, as they saw it, specific issues that they encountered in later life. So delegated decision makings through powers of attorney, long-term care funding, succession planning. There are probably, I think last time I looked, there are about 1,500 members across the UK, a number of them in Gloucester, and a number of them are also STEP members. So that would be a useful source to look at. Maybe as an alternative to that might be a charitable trust. So a company, trying to think, Mencap would be an example, Mencap Trust Company. So they act as trustees of trusts for people specifically with learning disability and autism. So they've recognised that parents may not have a able, willing person to assist them, and so you could approach them. Obviously, the benefit is that they understand the particular needs of the child through the nature of their condition. The organisation operates on a non-profit making basis and basically just charges costs, which can still be, significant, but it really is a good option. And I would say if you went to the charity or organisation that supports your particular child's issues and needs, then even if they're not able to offer the service, they're likely to have an arrangement or be aware of somebody who can. So up to now, that first categorization, if you like, is to deal with introducing the trust on the second death in the case of two-parent carers. So in other words, replacing the bequest that would pass to the child. But of course, there is scope to do that, exactly the same thing, but to do it earlier and to do it on the first death of the parent, or the death of the first parent. So, and that could make a real difference in the second time period that we're looking at, which is in the event that survivor might themselves need care. Because if the survivor needs care, then all of the assets that they have would be taken into consideration by the local authority under the means test. So what you've effectively created is what I would term a concentration of wealth in the hands of the surviving parent. Now, if they don't need care and they live happily for the rest of their lives, then it's not really an issue. But if they do need care, it can make a significant difference. So let's just take a simple example of a house worth of £350,000 and £50,000 in cash owned jointly by the two parents. The first spouse dies and leaves their share of the house, their share of the capital to their spouse. So effectively, that's £200,000, half of 350 plus 50, of extra assets in the hands of the survivor, which would be expected to be used for care through the means test in the event that they required it. If, on the other hand, you changed your will and you disinherited your spouse, which sounds very dramatic, and instead left your first share to a trust, then you would avoid that concentration of wealth. You'd effectively ring-fence £200,000 outside of the ownership of your spouse in the event of their death. Now, the key thing to be able to do this is to understand the way in which assets are owned. Basically, we can own things jointly, as we would do, for example, a bank account. And the law is quite clear on this. That asset can only pass on death to the other joint owner. Doesn't matter what you say in your will, doesn't matter what direction you give, that will automatically pass to the survivor. So we would always encourage older people to have small balances in their joint account and to have the bulk of their savings in separate accounts that are clearly designated to each other. And that's true for anybody applying for care, not just in terms of parent carers. When it comes to property, again, you can own your house jointly, and exactly the same rule would apply. The death of the first person would automatically see that pass to the second. So what you can do is you can, it's called severing the tenancy. Again, it sounds quite dramatic, but it is only a single sheet of paper in which you change your ownership to something called tenants in common. And what that does, it splits the ownership so that each party can leave their share to whoever they want. You can't do that to a bank account, but you can do it to a property. So by severing the tenancy, the joint tenancy, changing that to tenants in common, and then changing your will and adding a trust to hold the assets on first death, then you can protect your hard-earned wealth, both long and short term. Now, the spouse can still be included as a trust beneficiary. So, for example, that could pay top-up fees for care without the capital itself being means tested. That's the important thing. The trust owns the capital, and the person only owns the money that the trust decides to pay them or not to pay them, as may be the case. So as I say, not only does that improve the situation during the second period's time, it's going to help preserve more of the wealth that the parents had in the first place, but it's also going to help with the long-term position because you've now begun the process of setting aside funds in trust, ultimately for the benefit of your child. And obviously you need capacity to be able to change your will. So this isn't something to be left until sort of too late. You've got to think about it earlier. Now, the important thing about both of those two measures and both of those two time frames is that they are actions that only actually commence on the death of the individual. And because of that, their existence, the trusts only begin on the death of the person. So they're actually known quite commonly as will trusts because it's the will that sets out the establishment of that arrangement. So we've dealt with what happens on second death, and the trust could be deployed at that point. We've considered the option of deploying the trust on first death to provide protection during that period where the survivor may need care. But that just leaves us with the final time period, which is the chance to change arrangements before death. And this is the most contentious element, which is why I've left it till last and worked my way sort of backwards. Because there is a school of thought now that advocates moving assets into trust now, during your lifetime, and not waiting until death. So because this is deemed lifetime planning, in other words, it happens while you are still alive, what it means fundamentally is that the issues are not dealt with by your will, because effectively you are transferring some or all of your assets or property into a trust now. So this could be cash, investments, your house, and they would cease to belong to you from that point on, but instead be owned by the trust that you've established. Now, all the same issues apply as we spoke about earlier. The issue of trusts, beneficiaries, memorandum of wishes. But as I say, the key difference is that the trust begins today and applies to your assets today, not on death. So why would you do that? Well, these arrangements you will possibly come across or have heard about. They're generally referred to as probate trusts. The reason being that when you die, you don't own any assets because they're all owned by your trust, and so a grant of probate may not be required. So it's a probate avoidance trust in effect. So the first thing it does is it means you don't have to pay the fees that would normally apply in obtaining probate, which they vary hugely, but it's not uncommon to see 1.5% of the value of the estate plus VAT and disbursement. So quite a costly process for even moderate estates. The other thing is it avoids delay. With probate, you've got to wait until the process is complete before funds can generally be accessed, easily a year or more, whereas the trust carries on, it already owns them, so access to the funds is available kind of instantly. Now, we could spend another hour today going through the consequences of inheritance tax around the making of these transfers and gifts. And clearly we don't have the time to do that. But what I would say is that generally speaking, the IHT consequences, I find, can be managed reasonably well and still achieve the objective. So what we've got to consider, as well as the probate benefit, the avoidance of that cost process time, is that if either spouse during their lifetime then need care, then they do not own anything in terms of property or assets to be means tested, because it's now all been transferred to the trust. And this is where the controversy arises. Because at one level, the gifting away of assets could be deemed to be an act of deprivation, which is defined as divesting yourself of assets to avoid paying for care. But this issue is not clear-cut, and a key component within the means by which you would define this is intent. In other words, did you intend to effect this deprivation of assets in order to not pay for your care. So age, health at the time will be significant factors in how your local authority would view that. And the question that is likely to sit at the centre of that is, why did you do this if it was not to rid yourself of these assets and therefore be entitled to help from the state? We run a session separately on the issue of asset deprivation. It's one that we have been very reluctant to start. So we ran our first one last year, which was scheduled for an hour. And I think we ended 2 hours, 15 minutes later, which perhaps indicates the complexity of the issues and how much of an issue it is for families trying to plan. So I can't take you through all of that session again, but a lot will depend on how the trust is worded and the notes that go with it to explain why you have done this. And the example I'm going to just give, I apologise for this being a little bit bit direct, but I've actually got a copy of a trust deed that was established and the minutes that were prepared to sit alongside this trust deed, setting out what the client, what the person was doing and why. And I'm actually going to read you 9 points that were made within this trust document. I'll say I apologise for it being read out as it is, but it's important you understand what was said. And this is just under the heading, the purpose of the trust. The trust allows the settlor to express their affection and moral obligations towards his relations and to be assured that the people nominated will benefit from the trust. With challenges to wills having risen substantially in recent years and long delays in the estate administration, plus the legal costs, the trust will avoid such issues, which is really the point I was making earlier about the costs. Subsequent decisions will be trustee driven and will assist the trustees in making sensible decisions about the welfare of everyone concerned. The burden of property ownership passes to the trustees, which will assist the settlor as he advances in age with any problems in connection with looking after the property. Item 3, the settlor is aware of the increasing rate of dementia and the problems that this can cause. By putting the property into trust, the settlor can be assured that it has taken proper and responsible steps in the event of such incapacity occurring to ensure the property is properly maintained and looked after. Formalities surrounding the exercise of a lasting power of attorney and the possibility of having to make applications to the Court of Protection might in some situations make taking decisions with regard to assets cumbersome and unsatisfactory. The trust will prevent assets falling under the direction of the Court of Protection. There is also some protection against sideways disinheritance and the chance to preserve assets in the event of family breakdowns, death, and insolvency. The trust will assist my family with regard to estate planning and possible generation skipping, so that on the death of the settlor, if the next generation don't need the trust fund, it can be held for future grandchildren, for university fees, or funds to be loaned to them on beneficial terms. So what the person has done here is set out in clear terms a series of steps and reasons as to why they have put their property into trust. And it would be up to the local authority to read that, look at that, take into account their circumstances and decide whether they can demonstrate that deliberate intent to deprive themselves of capital for care funding has taken place. And I would hope you might agree that because there are clear and rational reasons set out, that would make that task a little bit more difficult for the local authority. Now, I can't tell you that that would work or would not work because it will depend on a whole range of other factors. If you were 65 when you did that, you would have much more chance of arguing that it wasn't anything to do with care than if you were 85. So every case will be looked at differently. But the real point I want to make is that in the example I've just read to you, that gentleman was not a parent carer. If they were, and issues were added into the reasoning as to why they're doing it, because their child is not capable, not able to receive these assets, not able to manage them or look after them, then I would argue that that would give a very strong argument about motivation, being the desire to provide for their child in the context of their disability or incapacity, and to reflect the fact that they couldn't look after them themselves. So as I've said, making a gift to trust in your lifetime is much more contentious and much more open to challenge in the event of a future care need. And the reason for that is because you have made that decision to transfer that asset today. Whereas if you haven't received funds through a will, arguably that wasn't your choice. It was the choice of the person who had the money in the first place not to leave it to you. You didn't have any influence over it. You couldn't control it. So there are no rules on what you do with your assets on death. So in the first two examples, the issue of deprivation simply doesn't arise. The person who did the transferring and gifting was the person who's now deceased. But a lifetime transfer is quite different. The owner did have a choice. So if a care need were to arise, you need to know that that action could be challenged. And each instance will be viewed on its individual merits. I should just mention, just as a sort of caveat to that, that we've seen an increasing rise. In fact, it's mentioned in one of those comments in the trust wording that there are more legal challenges to wills by disgruntled family members who haven't received what they thought they should have done. So I would always advocate that if you are not going to include a particular individual as a beneficiary who might otherwise have expected to be, it's a good idea to write it down and explain why. For example, I haven't left any money to my son because he stole money, never came to see me, or I gifted £50,000 to my daughter 10 years ago to help her buy a house, and therefore she's not included in the will. A little note about why I think will be helpful. So hopefully what we've done in that sequence is take you through the stages of life and the circumstances and to consider how, as a parent carer, you could consider taking action that would help to better manage your assets, to prevent your children from inheriting funds that would render them self-funded and therefore remove the local authority support that they would be entitled to. But I'm not trying to suggest that this is the way to go for everybody. I really just wanted today to open our minds and thoughts to how these things might work. Now, I've spoken to quite a few people who've been willing to pay the cost of setting up a trust on the basis that worst case scenario is if it's treated as deprivation from the point of view of care, then they're no worse off than they are today. And the opportunity cost, as you might term it, was worth it. But more importantly, they've done it because it will ensure the long-term protection of the assets when you consider the next generation. So yes, dad might die and that might leave mum having to use the assets to fund her care if deprivation is viewed, but it won't prevent the fact that money will still ultimately pass into that trust and not into the hands of the child. Now, you don't need me to tell you that we are currently in a situation where our care system is virtually under collapse through lack of funding, through lack of innovation. We've had successive governments who have just singularly failed to take any action to address the situation. And if everybody did what I have just outlined in terms of divesting themselves of assets into trust, then the simple fact is our system would collapse completely. So I guess there is a moral argument against what I've just outlined, and I think some solicitors would advise against it. for the simple reason that once you've passed assets out of your hands, you've also passed control potentially out of your hands, which may not be what everybody wants. But let's remember that today's session is about parent carers. And I think that perhaps for parent carers who've faced unbelievable difficulties during their lifetime and are desperate to provide for their child, I think we can maybe see why arrangements like this could be viewed as a justifiable solution to their situation rather than one which simply seeks to kind of find a loophole, if you like, around our care system. And as I say, these issues are hugely complex. And I don't want for one moment to suggest that we've covered everything. We have merely tipped a toe in the water to kind of open the door and look at them. And the ultimate advice I must give you is take individual advice, specialist advice about your situation. If you were to Google probate trust, I'm sure you will find firms, I know I did it a year or so ago, offering the service, but I would advocate tread carefully, especially on the issues and costs and wording, because I see some organizations presenting this as a kind of a sales idea rather than an advice issue. So just be careful that you get the right advice. I've mentioned STEP, I've mentioned Lifetime Lawyers. I would also mention SOLA from a financial point of view, the Society of Later Life Advisors, valuable source of help on all of these issues, in particular on the funding side. So what I hope to have done today is just provided you with some food for thought, some ideas that you might want to look at, and maybe some areas that you might want to explore a little bit further.